Lee Kim. Mōrena koutou, kia koe mātua Tom. Taraka. Can you unmute Tom?
No reira tēnā hui hui tātou. Kua tukoa mai e te kai whakawā, māku tātou hei whakatūwhera. No reira, kua ua manaakitanga no ki runga kia koutou kia tātou pai mārire. Weno e oku rangatira. Piki mai kake mai, haere mai muri, tuku muri hau te whanga mai mō tātou ma te tuatini, kua ke oki te hunga kua ke oki. E takatū nei te hunga kua mahue ake, me hakoa rā te ke te pūtea, e ri nei tara whare kia ki ake hau, ka watea. Rōrero kua wātea tātou i te kōwhiti te kaumā iwa, i te mate karauna. Tērā hau kotinga nui o roto o te ao, i hau kotia ai, a tātou whakawhitiwhitinga kōrero, whakawhitiwhitinga whakaaro. Ki tēnei o ngā ui ngā pātaitanga nui whakaharahara mō koutou o tēnei rohi. Nō reira, haere mai tātou, kāore kumea kia roa e nei me, oi nō rā, o te mea nui, kei te kite i te kanohi, tai hoa pēr mo tōna wā te ihu, e tūtaki ki te ihu, engari mo tēnei wā, tēnā koutou, tēnā koutou. Tēnā koutou katoa. Ngā mate o te wā. Ngā mate huhua kei runga kei o koutou pakihui, rātou ke rātou. Tātou te hunga aura. Koutou e te hunga roia. E tia ki nei i o koutou kai kreme, tēnā koutou. Koutou o te karauna, e tia ki nei i Aotearoa. Tēnā kōrua. Huri noa, he mihi poto kau, nāku, kia puru, ki ngā mea mahou, kia Dr. Phipps, e uru nei ki rote a tātauma. Ko mātou ko te kai whakawā, ko Robin, ko Basil, kanohi tawhito. Ngā kanohi hou kei roto i a koutou, ngā kanohi hou kei roto i a tātou. Tēnā koutou, tēnā koutou. Kia ora hui hui tātou katoa.
Kia ora. Kia ora Tom, i tautoko ana ahau ngā mihi kua mihia. Mōrena koutou, it's a pleasure to be able to resume a hearing for this important inquiry, albeit in this new manner. Could I just start, please, by reiterating the welcome Mātua Tom has extended to our new members. To my immediate right, Ms. Prue Kapua, and to my far right, Dr. Grant Phillipson, both of whom I'm sure need no introduction. Also with me in Wellington, to my immediate left, Dr. Robin Anderson, and to my far left, Mr. Basil Morrison. The way we'll proceed in terms of appearances and submissions is that I'll call for responses just from the list of council that I have. So just for appearances first, please, Ms. Rongo. Oranganui Legal.
Yes, Mr. Rongo here. I am appearing on behalf of two claims, Y78, which is a claim filed by Muriwai Jones, and it's on behalf of Ngāi Tai, and also Y1121 Rosanna Wiedepa, and that's Te Whanau Apanui claim, sir. Thank you.
All right. Kia ora, Ms. Rongo. Ms. Thomas, Kaupari Law. Oh, sorry, just get the audio. Thank you. Are we on? Ms. Thomas,
Can you hear me now, sir?
ai, ka pai.
Tēnā poe te kaipakawā o tira koutou katoa a ngā mema o te Traipuna e nono honei. Hei te pāpā, tautoko marika nau I o kupu kua wharikihia mu I a tātou. Kia rātau I tāniko atu ki te kahutapu rātau e whai tonu ana I te hui ngā tangata kua whetūrangi tia tia, kua iri rā ki tō tātou rangi. Haere mai haere. Koutou katoa e tūhonohono mai nei I roto I o koutou nā kāinga. Ka nui te mihi atu kia koutou katoa. Sir, ko Ms. Thomas tēnei e whakakānohi ana I te kreme Y1884 nā ko te hapu o Ngāti Ngahere tēnā koutou.
Tēnā koe, thank you. Ms. Clark from Wakro Williams.
Tēnā koe, sir. It's Miss Linstead Panaho here, appearing for Y1795, a claim by Tawhiri Mātea Williams for the benefit of Ngāti Rua Tākina Hapu. The Y1781 claim on behalf of Ngai Tamahaua Hapu, and also the Y1827 claim by the Wolfgrams as descendants of Rangi Hairepo. Tēnā koe.
Kia ora, Ms. Panoho. Mr. Was it Siausi Lau?
Tēnā koe, Your Honour. Apologies, my camera is not working at the moment. Just in terms of the claimants, is Y892, it's Dave Hauea on behalf of himself and Te Panawa Kai. Y2055 for Dr. Guy Naden and members of Ngai Tama. Leanne Martin for Y2107 on behalf of Ngati Ngahere and Ngati Ira, and Annette Hale on behalf of the late James Topi Wikotu, on behalf of the Wikotu whānau and Te Upokorehe. So.
Kia ora, thank you, Mr. Loa. Ms. Sykes.
Kia ora, kei te tukuna te rākau e nai nei ki tētahi o aku kaimahi, kia tūmana ko kei whakatau I ngā kreme, ei noho ki raro I te pakaro mā mātou o tēnei tari hei āwhina. Ana kei reira koe, I tēnei rā koutou mā o te rōpu whakamana o te tiriti, e whānga roia mai tēnei tari I āwhina ana e ngā kreme e ono, I runga I tau tuāhuatanga ko te hehie ma ia roia hei whakamārama kia koutou katoa, ko wai hei kōrero hei whakamanahia te whakaro nui o ngā kreme katoa. Kia ora.
Ai, kia ora. Kia ora, Ms. Sykes. Do you have with you? Sorry. Yeah.
Tēnā no tātou katoa ka hui mai, mihi ana kia koutou te Traipuna, o tira kia koe I te pāpā matua tōna nāwi I wātea I te papa ma mātou he kōrero, ka tika rā ka tuki ngā mihi kia rātou I whetūrangi hia, I runga I ngā huatanga o te tau matariki, ahunga nui, te mātātahi o te tau, tēnei ka mihi atu kia rātou mā kua whetūrangi hia. O tira ka tuku mihi kia koutou o Ngāti Rua Tākena, kia koe te ria ki amo, te rua rakuraku koutou ngā pōtikanga o te whakatōhia. Kua hau te kaiwa wāo, hei pāinga mo te kōti ko kua hau te kaiwa wāo, tūmana ko Silvera, Mō te kreme Y1782, mō te ria ki amo amo rawa ko Mereara Hata, mō Ngāti Ruatakena. Kia ora.
Kia ora. Tēnā koe, Mr. Silvera.
Ms. Sue, I don't think you've met her either, but Ms. Doherty Ware, could you please go next?
Tēnā tātou katoa o tira ki ngā mema o te Traipūnara. Ko Ms. Doherty Ware tēnei. I'm appearing on behalf of Y2510, a claim by Wiremu Te Kahika for Te Whānau o Te Kahika, Tia Kahika Roa and Whare Kahika. Tēnā rā tātou katoa.
Tēnā koe, Ms. Doherty Ware. Kia ora.
So the next appearance will be by Mrs. Cheney.
Tēnā koe te kaiwhakawā, koutou ko te rōpū whakamana I te stiriti, tēnā kia mihi kia koutou, me aku hoa roia, tēnā koutou katoa. Council's name is Mrs. Cheney, and I appear on behalf of Y864, a claim on behalf of the late Russell Hollis, John Brown and John Hutter. Kia ora.
Kia ora, Mrs. Cheney.
Ngā kreme e rua kei te toi, ko hau hei āpina hei māngai mō raua ngai kreme, ka huri au ki tērā o ngā reo, engari kei te tautoko au I ngā mihi, ki ngā mema hau, ko torua tahi, te mārei kura pū, me te whatu kura hoki Dr. Phillipson, pai te kiti a koutou I wainganui tēnā o ngā tūāhuatanga. Kia ora. So I appear for the two remaining claims. We have instructions for Ngāti Ira or Waiawika. It's a claim by the late John Kamita, and we've maintained his presence notwithstanding his passing just at the commencement of these processes. He's joined in the claim by Mrs. Paione Gunan, Ms. Taringahuia Hata, Ms. Amber Rosia Rakuraku, and as Mr. Silvera said, the Pautekanga for Te Hāhi Ringatu, who we also represent the other one, Mr. Roger Rakuraku. I can say that Mr. Roger Rakuraku is watching by live stream. He had hoped to mihi, but I think there was some technical difficulties, but he is available if there's any particular comments that need to be directed to him. I also appear for Mrs. Sharon Campbell, and nā whakatipuranga o rātou. He hapu anō rātou nā rāti rua, engari ko tā rātou nei kreme, he kreme pāna ki ngā haua o te whakatōhea, me ngā tāngata e noho mānene ana I ngā tāone. Kei te mātakitaki tonu Ms. Campbell mai tūranga ana I rungi tau tuāhuatanga kei te mihi kia koutou katoa, kia tātou katoa I tēnei ata. Kia ora.
Kia ora. Thank you, Ms. Sykes. Mr. Tupara.
Atamare kia koutou e ngā mema o te rōpū whakamana I te tiriti tuatahi, kei te mihi kia koe e te rangatira Tom Roa, no I whakatuwhera tō tātou hui me te nohonga o te Traipūnara tēnei ata, kei te mihi kia koe e te rangatira mō tēnā, me koutou o te Traipūnara, te kaiwhakawā, te tokorua kei tō taha matou me te tokorua kei tō taha Māui kei te mihi kia koutou katoa. Tupara e puta mai ana hei roia mō wai 2020 me te kaitono ko Priscilla Piritahi Sandys. May it please the tribunal, I appear in respect of Y2006. The claimant for that claim is Priscilla Piritahi Sandys, who marae is Roimata, and of the iwi te whakatohea. Kia ora.
Kia ora, Mr. Tupara. Mr. Lyle.
Kia ora, sir. I hope that the panel can hear me. I have very limited internet. I'm appearing from the sunny far north today. That's the reason that my camera isn't on. I'm appearing today for Y2066 and Y1553. Should my internet fail me, I'd respectfully seek leave to place my submissions in writing later on today, but I am hopeful that things will hold up.
All right. Thank you, Mr. Lyle. We can hear you fine so far. Ms. Floyd, Taha Legal.
Oh, tēnā koe, sir. Chris Beaumont here, appearing for a number of whānau Apanui and whakatohia claimants. For whānau Apanui, I'm appearing for Y778, Y779, Y808, 1808, sorry, Y1828, Y1829, Y2043, and also appearing for Ngāti Muriwai 12160. For Whakatohia affiliated claims, I'm appearing for Y2257 and Y2605. Kia ora.
Kia ora. Thank you, Mr. Beaumont. Mr. Stone. Mr. Stone or Azania Watini from Tamata Law. All right, I'll come back at the end to Mr. Stone. Mr. Benyon.
Tēnā koe ngā me mō te ōpū, e pā, Tom, tēnā koe. Mr. Benyon here appearing for Y1775, so a Ngāti Patamoana claim brought by Mr. John Hutter, Antoinette Hutter, also Russell Hollis, who's now deceased, carrying forward that claim on the basis, as Ms. Sykes pointed out.
All right, kia ora. Thank you, Mr. Benyon. Mr. Ketu from McCall Lewis.
Tēnā koe te kai whakawā, e te rōpū whakamana o te tiriti o Waitangi, tēnā koutou. Council's name is Ketu, appearing today for Y203, and that's a claim by Te Whānau a Mokomoko. Kia ora, sir.
Kia ora. Thank you, Mr. Ketu.
Sir, can I interrupt here? It's Ms. Sykes. I've just had a text message from Mr. Stone. He had instructed Kāhui Legal to appear for him today. He's briefing witnesses for Oranga Tamariki in Hastings, and like Mr. Lyle was having problems accessing it. So I understand either there's an agent instructed, but he gives his apologies to the tribunal, sir.
All right, thank you, Ms. Sykes. All right, I'll just come back to that and see if we have an agency appearance at the end. Ms. Alexander, I'm appearing for Ms. Swan.
Yes, good morning, sir. I'm appearing on behalf of Ms. Swan for Y1092, Y1758 and 1787 on behalf of Te Upokorehi Iwi, and Y1421 on behalf of Ramari Stewarts.
Kia ora, thank you. Is there anybody appearing from Kāhui Legal for Mr. Stone? No? All right. Mr. Lincoln, Crown Counsel.
Tēnā koutou katoa. Kei konei au mawako Daniel Hunt, te karauna I tēnei wā.
Tēnā korua, thank you. Oh, thank you. Sorry, thank you, Mr. Lincoln. I'd missed out Mr. Sinclair. My apologies. Are you on the line, Mr. Sinclair?
Can you hear me now, sir?
Yes, thank you.
Yeah, seem to have some technical difficulties. Te mea tuatahi he mihi ki a koutou ki te tribunera e whakamana te Tiriti o Waitangi. Te mihi tuarua ki te rangatira whakatuwhera te hui tēnei wā. Te rangatira no Tainui, tēnā koe, tēnā koutou. Ia koutou katoa, I mihi tēnei, o te tai rāwhiti, kia tātou katoa. Nō reira, ko waio. Sir, my name is Sinclair. I'm appearing for Y87, the Whakatohea Raupatu claim. I'm appearing for Y1794, Tūranga Piki Toi claim, and for Y339, the Hiwaro C claim, Dean Flavel. Thank you, sir.
Thank you, Mr. Sinclair. All right, just moving to the first matter on our agenda, which is the resolution of the district boundaries. I just want to make a couple of preliminary points. The first is that and I'm talking generally of tribunal practice, the boundaries are primarily administrative in character and commonly are drawn to align with adjacent district inquiry boundaries and commonly do not accurately follow hapu or iwi rohi. So the current draft inquiry district boundary had been drawn along those lines, reflecting the adjacent Ngāti Awa, Tūhoi and East Coast inquiry districts, then adjusted back to exclude whānau Apanui rohi on the indication from that hapu iwi collective that they were pursuing the negotiations alternative. In light of the submissions that we have received to date on the boundaries, it's our preliminary intention to extend the boundary, and I think we're talking broadly towards the north to include all of the Ohiwa Harbour, and would be pleased to hear if Council have any submissions on that today in terms of where the boundary would best sit on the landward northern side of the Ohiwa Harbour. For those claims which would extend beyond our current indicative boundary towards the south, and those are the Whakapōkakihi claims. Mr. Sinclair, I think, aspects of the Y87 claim which go towards or touch into the Mangatū blocks, possibly claims that have an interest in the Tāhora blocks. Our intention at this stage is that while our notional boundary might not incorporate all of those particular blocks, it would be our expectation that we would extend boundaries to here, those claims on the understanding that they are the claims of essentially non-settled claimants, hapu, within our properly within our inquiry. So that's just a preliminary indication of where our understanding is at the moment. We have received a recent confirmation from the chair of the Hapu Collective for whānau Apanui that they wish to remain in negotiations and do not seek participation as a collective, although they support the participation of their border hapu as interested parties. So on that side, we broadly expect that our boundary will remain where it currently sits on that Ngāitai and Apanui border. So what I'll do now is I'll call Council again in the same order that I just have and seek any submissions that Council wish to make on the boundaries. Then I'll just seek from my panel whether there's any questions as we go, and we'll move through the through our agenda in that fashion. All right. So, Ms. Rongo, do you have any submissions on this matter?
Thank you, sir. Yes, my Y1121 claimants who are Whanawhanui claim are very happy to hear that the Trust Board do support them in continuing on with their claim. They would like their area included in the boundaries, so that's their submission. And the Y78 claim for Ngaitai, they do wish to participate in this inquiry, so would appreciate if they were definitely included in the boundaries. But from what you've said, sir, it sounds like my claimants will be very happy with that. Thank you.
All right. Just thank you, Ms. Rongo. Your Upper Nui claimants, does their traditional interests sit in that border overlap area between Ngaitai Upper Nui?
It's a little bit more east than Ngaitai, sir, in Whanaroa, but not too far.
Right. Whanarua Bay, that area?
Yes.
All right. The hapu affiliation of your Upper Nui claimants, do you know which hapu or hapu they would affiliate?
I do, sir. I don't have it on me right now.
All right. Could I ask that perhaps you just confirm that in a brief submission within the next week?
Oh, they're from the hapu Kahurotau.
All right. Kahurotau.
Tau, T-A-O.
Thank you. All right, Ms. Thomas.
Tēnā koe, sir. Ka kāre aku kōrero tāpiri mo tēnei take nei. I nā hoki e noko ana ngā pānga wā ku kiritaki I roto katoa I ngā tūtohu whenua kua whakatakotohia kētia e koutou. Anō reira e tautoko marika ana I ngā tūtohu whenua o naine.
All right, ka pai. Kia ora. Ms. Clark. Oh, sorry, Ms. Pānoho.
Kia ora, sir. Kia ora, sir. In terms of the boundary issue, our claimants had filed submissions regarding the Ohiwa Harbour and the inclusion of the entirety of that within the inquiry boundary. So that's something that you've indicated already this morning that the tribunal is looking at, which we would support. In terms of where the boundary marker might be, I'd need to seek instructions on that from the clients, but I am aware that Marae Tōtara is a significant site for our clients, so that would certainly be somewhere that would need to be incorporated in the boundary.
All right. Kia ora. Thank you, Ms. Pānoho. Perhaps if I just indicate at this point to all counsel that with respect to this issue and all of the other matters on our agenda, in light of the fact that we are proceeding by Zoom and there are some difficulties with that process, I reserve leave for any follow-up or supplementary submissions to be filed in writing by the end of next week. So that if a matter arises today which council aren't able to address because of the procedure we're following, then they can be picked up in a supplementary written submission to be filed by the end of next week. Thank you. Mr. Lau.
Kia ora, it's Mr. Law.
Law,
I just
sorry.
have a that's right. Sorry. I just have a technical question in relation to the boundary to the south. According to your first direction, that the boundary was the Turanga Inquiry.
Yes.
Is that correct, Your Honour? And the current boundary that's shown for that's the 2.5.1 map, it does not actually go up to the Motu River, which I believe was the boundary for the Turanga Inquiry. And I'm just wondering if that could be extended to the river, or are we staying with the boundary that you have now?
All right, thank you for pointing that out. If there is a discrepancy, I'm not sure what the reason is for that. So I'll ask for some advice about that, and we'll address that issue in the directions that will follow this this conference.
Thank you, Your Honour. And just the other thing is the boundary goes along the Motu River, then at the puna of the Motu River, along the northern part of the Motu block towards the west.
And that's the Turanga Inquiry boundary, or the inquiry boundary your clients seek?
The Turanga Inquiry boundary, I believe, sir. I was just informed this morning from our client, and I haven't had time to check that.
All right.
But I will make submissions in writing.
All right, thank you. That would be helpful, and we will also look at the current indicative boundary line, and if there is a discrepancy between that and the Turanga Inquiry boundary, then we'll clarify or correct as needed.
Thank you, Your Honour.
Thank you. Ms. Sykes, should I proceed through your counsel in the order they spoke? Mr. Silvera first.
Well, I think I should go first in light of Mr. Law's comments, because I don't think they'd be aware of this. I have to agree that the boundary must go to the Turanga Inquiry boundary at the very least, in strict terms. But several of my claimants sought to participate in the Turanga Inquiry, and the Chief, well, Justice Williams, as he is now, denied our right of entry. And it was on the expectation that our claims would be heard, including those claims in the Whakapau Pākehī blocks and the Motu River claims in a whakatohia or to be convened whakatohia inquiry. So we are naturally alarmed that that doesn't seem to be the case on the documents before the tribunal. That's the first point. You might recall that Mr. Silvera's knowledge keeper and tohunga of whakatohia gave an oral boundary at our first judicial conference. And he set out very clearly in conceptual framework terms all of those markers which aren't included in this current boundary, and there's been no adjustment. So that's a bit of a concern, and except for Your Honour's intimation this morning that we may extend the boundary to Marae Tōtara. Now, we've provided to the tribunal a corrected version of that oral testimony, which is being checked by the tohunga, and I think that's very clear, the areas of interest that extend for the whakatohia hapu as a whole, but for his particular hapu as well. If I can turn to my particular clients, because those matters may want to be amplified, particularly by Mrs. Cheney for the Mautohuaroa Quarry claimants. So they've tried to get into the Tūhoe claims, they tried to get in the Turanga claims, and now on this map, their claim isn't in. So it's a real problem. And while it's all very hard to say that they're the unsettled groups, or they've been trying to deal with this matter for nearly 30 years. They've had 2 of their people die. It's just simply not an approach that I think gives transparency to the need for justice for some groups. It's like we're the afterthought.
Hi. Ms. Sykes, just in terms of the boundaries that Te Reaki Amoamo had laid out at the previous JC, we have asked for some indicative mapping of those internally as well. I will ask that that be checked against the corrected transcript, because I hadn't picked up that you had filed a corrected version of that, those traditional boundaries. So we'll do some internal work to just see how that sits with the current indicative boundary line and the adjustments that that might follow. So I do just want to confirm that whatever the administrative lines finally, whatever shape they take, it's certainly our intention to include claimants such as those you are describing who have not had the opportunity to be heard in other districts. So we certainly want to make that absolutely clear, that there'll be no intention to exclude those who've had that unfortunate experience of long seeking to be heard and not had that opportunity.
Thank you for that information, sir. The other difficulty we have is we're all involved in a MACA process. I'm sure that the tribunals have raised of it. And we've had extensive assistance in getting mapping done for many of us that are appearing today. We have a difficulty in that the High Court has directed that any evidence relied upon there is not available in exact form to be provided to any other forum until that's been adjudicated upon. We go into an 8-week hearing on the 17th of August. I don't know how long that adjudication is, but I'm just thinking about costs for my applicants, and I'm specifically talking about Ngāti Ira. We have done a significant mapping exercise, which we would like to place on the record at a suitable time, sir, is all that I'm saying. They are controversial to the extent that some overlapping claimants from Te Whānau Apanui Ngāti Awa may disagree with the areas of interest that are claimed by our hapu. But I do think that they are very helpful pictures of the areas under claim, and in particular, how Raupatu served to dispossess Ngāti Ira. So I'm just signalling that so we don't go into another mapping exercise at a significant cost, because we were assisted in this regard by a very helpful tool that's been developed by Te Arawhiti. And Moka Āpiti was contracted by us, and they've got all these overlays of maps that they've used as their database tool, which would be a great tool here, sir, if we were to construct a map based on those conceptual boundaries that Mr. Amuamu and other traditional knowledge keepers have given to this forum. I just raised that.
All right, thank you.
Apart from that, the general propositions, I think we agree with, but I am, my Ngāti Ira claimants are a little bit frustrated. Te Hira Te Pōpō gave significant evidence in the Native Land Court in the Tahora hearing, sir. The block reports and the Urewera inquiry and the reports that are on this inquiry from there have significant testimony from Mr. Hira Te Pōpō. So the Tahora blocks and the whole saga around the Rees Carroll and the Sim Commission investigations, I think are worthy of consideration by this tribunal as a consequence.
Thank
so
you,
the
Ms.
map
Sykes.
should include those areas.
Sorry, the name of the opponent in the Hira.
Hira Te Pōpō.
Thank you.
He's very famous, sir, and you'll hear a lot more about him as the hearings progress.
Right, thank you, and thank you for that indication in relation to the maps and the MACA evidence. We'll perhaps have a further discussion about that in terms of the timetable going forward. All right, so next, in terms of your counsel, Ms. Sykes, Ms. Cheney, is Mrs. Cheney or Mr. Sylvia? Mrs. Cheney?
Tēnā koe, sir. Thank you. My claimants support the extension of the boundary, particularly to encompass the areas of the interest that they've alluded to insofar as it extends to the Mangatu Forest, and that's around the Whakapau Pākehī blocks. Other than that, sir, unless Your Honour has any further questions, those are the submission 4x864.
All right, thank you, Mrs. Cheney. Mr. Silvera?
Tēnā koe te kai whakawā. He āpiti noa i ngā kōrero tā ene. ka tautuko au I wera kōrero. Ngā kōrero I whakatakoto e te koro te ria ki amuamo, mō ngā rohe-rohenga, kei roto amara I tōtara I tērā I taua rohe-rohenga. Koe rā noa tāku hei āpiti atu I ngā kōrero.
Tēnā koe. Mrs. or Ms. Doherty Ware?
Kia ora, sir. I don't have any submissions on this particular issue other than supporting the kōrero of Annette.
Right, thank you. Mr. Tupara?
Kare kōrero, sir, no submissions.
Thank you. Mr. Lyle?
Kia ora, sir. My submissions remained the same for my claimants as they were in the August 2019 judicial conference. For the Y2066 claim, we support Mr. Law's comment that the boundary ought to follow the Motu River, but doesn't appear to presently. So we'd welcome you making inquiries and seeking advice on that shift. For my whānau Apanui claimants, that's Y1553, they're in the same boat as Ms. Rongo's claimants and whakapapa to the same hapu, and their claim issues appear to mirror the area as well, extending from Portiki out to Whanaora Bay. So we'd welcome a relatively porous border there if that claim is to be heard.
All right. Thank you, Mr. Lyle. Mr. Beaumont?
Kia ora, sir. We represent a number of Te Whānau Apanui claimants who personally are not keen to support the negotiations process that Te Whānau Apanui are currently engaged in. So they do certainly appreciate what you said about being open to hearing Te Whānau Apanui claimants as interested parties in the inquiry, despite the boundary possibly excluding Te Whānau Apanui just rohe as a whole. However, these claimants would seek inclusion beyond being simply interested parties. They would want to be full parties to the inquiry, given that, like other claimants, they have not had a chance to be heard in other inquiries. So with your leave, Your Honour, I would like to make some further submissions in writing about this particular issue.
Yes, that would be helpful. I gave that indication earlier that we'd seek any follow-up submissions by the end of the next week. Are you able to meet that timetable for these submissions of this character?
Yes, we can do that.
Because what we would need some clarification about is the hapu affiliations of the claimants, the areas of interest around which the claims centre, because there is an issue for this tribunal in how we manage recognition of genuine overlap and around the boundary, and the indication we've had from the Apanui Claims Alliance or the Hapu Collective that they wish to pursue the negotiations path. So we will need to consider how to balance that factor and also to properly understand and hear the interests that where they overlap around the border. But beyond that, there'll be an issue for us if we're being invited to essentially conduct some form of de facto Apanui hearing. So that we will seek from you some clarification so we can properly understand the nature of the clients you represent, where their interests lie. So if you can provide us with as much information as possible on those matters so we can consider how to proceed, that would be helpful.
Yes, certainly, sir. We can do that.
Thank you.
And that's all my submissions on that matter, sir.
All right. Thank you, Mr. Beaumont. Mr. Stone, or is there anyone currently appearing on instructions for Mr. Stone from Kahui Legal or anywhere else?
We're trying to get some. I've got someone on call for him. I know his difficulties. We're trying to work to many deadlines. I suggest perhaps we do it by asking him to file a formal memo, but we'll take notes for him today so that he can do something over the next couple of days if that's a suitable approach.
Yes, yes it is, and thank you for that indication. Mr. Benyon?
Yes, thank you, sir. We support the submission about the extension of the northern boundary westward to take in the Marae Tōtara stream, and that's consistent with previous submissions that we've made. And we don't have any comment on the southern boundary issues.
All right, thank you, Mr. Benyon. Mr. Ketu?
Kia ora, sir. Yes, I'm in the same position for my clients and would support Ms. Pahono Linstead's submissions around extending it to Marae Tōtara as well, and including the entirety of the Ohiwa Harbour, as you've indicated this morning. Thank you, sir.
Thank you, Mr. Ketu. Ms. Alexander?
Thank you, sir. Our clients would also like the boundary extended to Marae Tōtara or the Ohiwa Harbour, as you've indicated.
All right, thank you. Mr. Sinclair?
Sir, submissions for Y1794, Y87, and Y339 regarding Ohiwa Harbour. They support the submission that Marae Tōtara be the westernmost boundary, Whakatohea. It's a submission on the Ohiwa Harbour, sir. Moving now to the northeastern, the southern eastern boundary. Sir, they'll be pleased to hear your submission that the Waitangi Tribunal will inquire into those blocks outside of the designated area to date. And that was, sir, if I may add, that was a reason why the applicants sought a discrete inquiry should the tribunal, for some reason, not be able to accommodate those boundaries, sir. So they'll be happy with the development. Sir, the extension of the southern boundaries to include the Waipawa blocks, and going further, sir, down into Matawai and to the Ormond region. Sir, I'd take the opportunity to make further submissions on that particular boundary point. So for reasons that the applicants have further evidence that there were another reservation which many whakatohea were moved to in those particular area of Matawai toward the Ormond area. So, sir, I think I could file submissions within the next week regarding that matter.
That would be helpful. Thank you, Mr. Sinclair.
Yes. Sir, there's a lot further research needs to be carried out regarding the Waipawa blocks. At presently, there's only been one ancestor who's been identified, one ancestral line, sorry. But there are several others, sir, and other hapu that were involved in those land blocks in those particular areas. Sir, in regard to the
Mr. Sinclair, sorry, just before you move on, will you be able to, within a week, in terms of any submission you wish to make about including blocks such as the Waipawa or areas around Matawai and Ormond, will you be able to provide what information you have about the historical connection, including any whakapapa lines, by next week, or do you need more time?
Sir, given the circumstances of Y87 at the moment and being in the High Court, sir, I think I'd need a little bit more time for that, sir.
All right. It may overlap with another of the matters we need to discuss today, which is essentially eligibility criteria. So we might set a date a little bit later for matters such as that. All right. Sorry, Mr. Sinclair.
Thank you, sir. Thank you, sir. That ends my submission.
All right, you were going to say something about the Mangatu blocks?
Oh, sorry, sir. Just in regard to the Mangatu blocks, sir, my clients don't wish to relitigate the Mangatu blocks at this juncture. However, the Mangatu blocks and the shared interests with the Waipawa blocks and Whakapau Pākehī blocks and surrounding blocks is difficult to separate. So, sir, whilst not wanting to deal with the matters that have been dealt with before the hearing, which is near conclusion regarding Mangatu, those matters of shared customary boundaries and interest will be included in evidence filed for Waipawa. Roundabout way of saying, sir, Y87 applicants do not wish to relitigate Mangatu or file submissions regarding Mangatu, and except insofar as there's a whakapapa and shared relationship with the other blocks there.
All right. Thank you, Mr. Sinclair.
Thank you.
Mr. Lincoln?
Your Honour, sorry, it's Mr. Law. Could I just interject just for a second?
Certainly.
Your Honour, I was just interested in the discussion you've had with Ms. Sykes and Mr. Beaumont in relation to groups who have not been heard. We represent the Y892 claim for Te Whanau Akai, and subject to instructions from the clients, we would be seeking to have their claims heard within this inquiry as well, if that's a possibility, or if that's available, Your Honour. And we will make submissions in relation to that.
Can I ask?
So before you rule on that, I just need to alert the tribunal because it seems like our documents aren't getting through. We've done an amended statement of claim, which is quite very full. We've instructed Mr. Ian Millard, Queen's Counsel, to assist us. We've only had that claim registered despite it being with the tribunal for over 6 weeks. I think COVID got in the, so we don't have a problem, but we will be making extensive submissions to the Mangatu inquiry in light of the High Court decisions. I'm sure I don't need to elaborate on here. I'm saying that we have a right to be heard in this inquiry for claims into that area, and we'll just leave that point at that matter at that point. We are, Mr. Millard QC is presently on our instruction drafting memoranda to file with the with Judge Milroy's panel, so on those points.
All right, thank you for that indication. Mr. Law, again, I think we'll need to receive your submissions and consider them in terms of your Y892 claimants.
Yes, Your Honour.
We will discuss shortly some dates for filing of submissions on these points. Mr. Lincoln? Sorry, you're just cutting out there on the audio. Sorry.
Yes, I'm having some audio issues at the moment. I might need to rejoin the conference.
I can hear you well now.
Oh, good. Well, I'll be quick on this issue. Every submission we've heard suggests that Marae Tōtara is the logical boundary towards the western end of the inquiry, and that would encompass all of Ohiwa, obviously, and therefore address all of those issues. Similarly, there's a strong consensus, I believe, in the submissions for the Ōpape headlands to be the eastern coastal side of the boundary, and so in that respect, the indication on behalf of some Te Whanau Apanui groups about having a boundary go further east would need submissions to substantiate it, I think, and we would seek to reply to those in writing. The interested party proposal means, of course, that groups can be heard on what their interests are, but their claims would not be inquired into. And it sounds from Mr. Beaumont's submissions today that he would be seeking more than that. Heading inland, it's encouraging, sir, to hear the tribunal's preliminary indication about not about using the proposed boundary for administrative purposes, while not using that as a means to prevent claimants from these hapu advancing their claims into land blocks that extend further to the south, for instance. And so, subject to seeing the submissions for claimants, we would be content to follow an approach like that as a very practical means of moving through the issue. I was reflecting on Your Honour's initial comments about the administrative nature of those boundaries, and they were often set up for district inquiries as a way of controlling what would be tackled now and what would be tackled later. And I think it's important to recall that, because we are at the point now of later. And so there really isn't prejudice to the adjacent districts in my submission from now moving to hear all of the claims to blocks by these groups, even though those claims will go over those administrative boundaries. Those are my points on this topic, sir. Thank you.
Thank you, Mr. Lincoln. That's helpful. I'll just check with the panel whether they have any questions in relation to the boundary matters before we move on. Matua Tom, do you have any questions? Okay, thank you. The next matter we had on our agenda was timetabling, including claim eligibility. That overlaps a little bit with the next matter, which was inquiry, hearing and interlocutory timetable. But if we could just turn to the immediate question of a suitable date for submissions from a number of council in relation to the claim eligibility matter. If we just focus on that for the moment. So we, I think, need to hear from further from, among others, Mr. Sinclair, Mr. Lau, Mr. Beaumont, and possibly others about consideration of party status, interested party status, and the nature of claims outside our notional administrative boundaries at the moment. So I am conscious also that a number of the parties are shortly to be engaged in the MACA proceedings, but I was going to suggest we allow perhaps around a month from today for submissions on the and clarification of those parties who seek a particular extension of the boundary, a particular further submissions on whether they ought to be granted interested party or full party status. So if is a month sufficient is the question, or is more time needed? So if I can just again move through those council who wish to be heard on this matter, we'll come next to the broader question of what our timetable needs to look like moving forward towards hearing. And our understanding is that we are still trying to work towards commencing hearings with a focus on the Raupatu issues. So we'll come to that next. But just if I could hear from those who wish to be heard on a month for further submissions around claim eligibility and status. So Ms. Rongo, do you have any submissions on this matter?
Yes, we will need to file something in writing, especially concerning the status of full party or interested party. I can outline now that both Ngātai and my Whānau claimants would like to participate as full party. And we'll need to, of course, put in writing our submissions concerning the boundary extensions, as Ōpape, the eastern boundary, would cut Ngātai claims in half as they go from Tirohanga right up to Hawaii. So a month should be fine for us, sir.
All right, thank you.
Thank you.
Ms. Thomas?
Tēnā koe se pai ana te tahi marama.
Hi, ka pai. Ms. Panoho?
Don't anticipate that being an issue, sir.
Thank you. Mr. Lau?
Thank you, Your Honour. Yes, subject to instructions from our clients, we believe we will be able to make that time frame. Just for further context, Your Honour, so the Te Whanau Kai tried to be heard in the Tūranga inquiry and didn't quite get there. Tried to be heard in the East Coast inquiry and didn't quite get there. So they are seeking an opportunity to be heard by the Tribunal in relation to all their claims, Your Honour.
All right, thank you. Ms. Sykes?
I just need some clarification, sir. I think 4 of our claims are clearly claimants that will fall within the rohe. Mrs. Campbell's claim is what I would call an urban Māori claim that shows the pathways of disconnection for groups from Te Whakatohea who were the diaspora following the atrocious events of the Raupatu. So while her claim is filed for on behalf of her whānau as descendants of Ngāti Ruatākega, a lot of her whānau are in jail or have suffered suicide or mental health issues, but more fundamentally are disconnected from tribal repositories of knowledge. So do I need to make submissions? Because in the Tūhoe inquiry and the CNI inquiry, while they were urban Māori living outside the rohe, their claims clearly had its genesis from acts within the rohe. So I just, this could, how long is a piece of string? If I needed to take that further step, I would be seeking a little bit of an extension, largely because I'm just swamped with time frames that even the 4 of us can't meet, sir. Remembering I also practice in the criminal jurisdiction, and COVID has, there was 900 people arrested, and we're in court just about every day, sir. So it's a very difficult, or it's a challenging time for us to juggle timetables, particularly where we may need to write evidence.
All right. Ms. Sykes, just in relation to, is it Ms. Campbell's claim, if I have understood you correctly, the claim centres on the historical or the long-term historical effects of the Raupatu, which is clearly among the central issues for this inquiry. So I don't anticipate, if that is essentially the genesis of the claim, even though it has contemporary aspects, that there would be an issue relating to the boundaries or the jurisdiction. So if that's helpful, it may avoid...
I'm glad to have it on the record, sir, because the registrar of this tribunal has been having difficulty coming to those conclusions so we can get legal aid, sir. It's a real fundamental problem. The question being raised is she eligible to be a claimant in this inquiry? And I've never struck the kind of difficulties we're having now with legal services. But, I quote those 2 examples. I had Maraea Rakuraku in Tūhoe. She did all the urban claims there. So, and in the Te Arawa claims, I had several claimants who lived outside Te Arawa.
Right. And
we had more problems. It would be helpful if we had a direction to that effect.
So is that claim, Mrs. Campbell's claim, has that been registered, or is it in train?
Just yesterday, sir, after our 4th attempt to get it registered, right, sir. And we're still now in submissions with legal aid.
All right. So you're indicating that a month might be difficult depending on where some of those matters land. All right. So even if we said, well, I'll take that into consideration, and we'll hear from the other counsel and see if a different date might be more prudent. Thank you. Mrs. Cheney?
Thank you, sir. No further submissions beyond those made by Ms Sykes. Thank you.
Kia ora. Ms Doherty Weir.
Kia ora, no further submissions on this.
Thank you. Mr Silvera.
Tēnā koe e tautoko ana I ngā kōrero tāene. Kia ora.
Kia ora. Mr Tupara.
Kia ora, sir. Kārehe kōrero mō Y 2006. No submissions to be made in regards to this matter or this issue for Y 2006. However, I have to declare my interest. I am of Te Whānau Ākai, and I would tautoko the initial submission made by my colleague, Mr Law, in terms of Te Whānau Ākai seeking participation in this inquiry. They're very strong interests historically into Te Whakatohea, into the rohe, and I would support that initial submission and file submissions. We would, subject to instructions from our client, of course, file submissions in support of that specific application that Tamaki Legal will be making in due course, sir. Thank you.
All right, thank you. Mr Lyle.
Kia ora, sir. Very comfortable with 1 month time frame, but I'm in the tribunal's hands if a longer period needs to be set down to accommodate some counsel.
All right, thank you. Mr Beaumont.
Kia ora, sir. We support the 1 month time frame suggested.
Thank you. Mr Benyon.
Kia ora, sir. Support the 1 month.
Thank you. Mr Ketu.
So supportive as well, and nothing further to add.
Thank you. Ms Alexander.
Supportive, sir, and nothing to add.
Thank you. Mr Sinclair.
Tēnā koe, sir. I support the 1 month period to file submissions. Sir, the submissions will focus largely on the amended statement of claim blocks that were filed for Y87, 19th of June, sir. So they shouldn't present any difficulties there. Thank you.
Thank you. Mr Lincoln.
Kia ora. Supportive of this being a topic largely dealt with on the papers, and would seek to be timetabled so as to respond to what the Claimant Council put forward. As to an appropriate amount of time to prepare that response, while I'd like to suggest a fortnight, I'm a little nervous that that may be a bit optimistic. So it may need to be possibly more like a month or so. Can I also just raise one further point? There's possibly a risk if the submissions on eligibility are self-selecting, in other words, only those Claimant Council who have sort of clearly identified for themselves that there's an issue here that they need to square away with the tribunal, go to the trouble of putting the submissions. And I wonder whether the timetable should set it up as an obligation on everyone to confirm that the claims they list are eligible, rather than us risk overlooking people through through accident or whatever, and not realizing till later in the process that there's someone who seeks inclusion and has been assuming they were included, but didn't get around to positively saying so at this point now. Those are my points there, sir.
Are you suggesting, Mr Lincoln, a date by which we can, in the absence of a positive indication, we can then proceed on the basis that we have a confirmed list of identified claims that'll be the subject of this inquiry? So, in other words, if well, we may have notional claims on those before us. If we don't hear from final word from parties by a certain date, we proceed on those we have the indication from.
Yes, I think so, sir. And obviously that wouldn't stop someone applying later for the tribunal's leave. But I'm just conscious that what's been proceeded with so far has been an indicative list of claims that might be eligible. People now need, in my submission, to positively say that they come within the eligibility criteria the tribunal is setting, and then any issues from that will become apparent to respond to for the Crown and for the Tribunal to consider in due course, and we will have expressly squared all of this away. Thank you, sir.
All right, thank you. Does the panel have any questions on?
I just have one.
Sorry, yes, I'm just going to tell you. I'm going to just put your panel member Prue Kapua has a question.
Kia ora koutou. Just to Mr. Law, I just wonder if, in relation to your comment that whānau Kai weren't heard within the context of the Tūranga inquiry, whether you could clarify in your submissions whether you're referring to the hearing or whether you're referring to the settlement negotiations.
Thank you, Ms. Kapua. I'm referring to the hearing itself.
And is that for the Y892?
That's correct.
Okay.
Sorry, it's subject to instructions from the client, so I've got to confirm that with them.
I just think it might be helpful to look at the report and then to the issues, obviously, in relation to the mandate and negotiations, because it does appear on the face of it that it was dealt with within the context of the Tūranga inquiry. So it would be good to have clarification as to the basis of that assertion.
Yes, Ms. Kapua. So the matter just arose today, and I haven't sought instructions yet, but I will confirm that and make those submissions. Thank you.
Thank you, Mr. Law.
So it's Ms. Sykes here. Can I also clarify, because we're likely to be cross-claiming with the whānau Kai. They were a significant claimant in the Te Urewera inquiry. Kensington Swans, Mr. Boast Queen's Counsel, represented them in the Te Urewera inquiry, and they have significant findings in there, which we rely on in our amended statement of claim for Ngāti Ira, because there was a group of people that were labelled as rebels, and so I'm a bit confused as well. So I'd like to have some clarification about if it, our groups weren't inquired into in any inquiry. I just put it that way. That's just something I'd like clarified for my claimants.
Tēnā koutou, it might be possible to clean this up pretty quickly. I can confirm that Mr. Dave Harware for Te Whānau Kai is alive and well and an active participant in the Tūranga inquiry, which, as everyone knows, is still continuing, and is represented by Tamaki Legal Lead Counsel, Mr. Naden, and assisted by Mr. Amro. And so I suspect there's just been a slight miscommunication there, because it's very much an active participant in that inquiry.
All right. Thank you, Mr. Lincoln. Just coming to the inquiry timetable going forward and the next, including interlocutory steps from here, can I just give this indication in terms of our current progress on the research indicated in the casebook discussion paper? I understand from staff that the next phase of research, which is underway, or if not underway, will shortly commence, is expected to be complete on or before March next year, and that's the post-1874 Raupatu implications and political issues arising from that, 19th century land issues, tribal landscapes report, and I think one or two other, include possibly block history work. So I just give that indication. Now, our understanding from previous judicial conferences is that we would look to set a timetable to move as soon as we reasonably can towards a priority hearing on the Raupatu issues. As we understand it, as at now, allocating resources towards research from the tribunal's own resources and budgets. We're not aware of, at this point, any alternative sources of funding, although we have received an update recently from CFRT that they will be considering, or the trustees will be considering, an application around mid-August, I think from Mr. Sinclair's clients. But at this stage, we're proceeding on the basis of the research program we have set. And that has obvious implications for the timetable. So if I could again call on Council just to make what submissions they wish in terms of the steps towards initial hearings on the Raupatu issues, and when those hearings might be possible, and working back from that, what a timetable might look like. Once again, we'll reserve leave for parties to make written submissions on this point, but if Council have brief submissions to make now, or if there are any other priority research matters that might affect the timetable that Council wish to raise, it would be good to hear that now. Ms. Rongo?
Yes, thank you, sir. In terms of steps toward the initial hearing, I know that my claimants that we represent are supportive of prioritising Raupatu in the hearings and having those issues run first. And in terms of the possible timetable, what it might look like, so we're happy to abide with any decision that the tribunal makes in that regard, just bearing in mind that there are other inquiries running as well that look to start hearings in 2021 as well. But thank you, sir.
Kia ora, thank you. Ms. Thomas?
Tēnā koe, sir. Hako e horokoku ana ki te whakai ki tāte krauna kōrero, kei kona iau e tautoko ana i te kōrero a Mr. Linkhorn. Ahua hoki whakamuri ana mō te confirmation of participation, nā te mea e tautoko ana i tāna kōrero mō taua take. Mena e whakaro tonu ana tātou mō te 20th of August, taua takiwara, mō te tuku o ngā tāpaitanga mō te rohe o tēnei pakirehua. E tāpai ana i tēnei wā kia koe te tiati, me whakatau anō taua wā mō ngā kreme katoa kia tuku i ngā tāpaitanga, mō te whakau anō o tā rāua noho ki roto i tēnei pakirehua, ka mutu ko ngā eligibility anō hoki i taua wā. Nā kona, he pai kia au te toru wiki kia te krauna ki te whakahoki i ana tāpaitanga mo aua take e toru. Mena e tirohi ana tātou ki te pairoa ki te hōtaka kei mui a tātou ka whai wāhi pia te traipinara ki te whakatau i te rohe o tēnei pakirehua ka mutu ki ngā kreme katoa e noho ana i tāna rohe, nā ko ngā consolidated me ngā aggregated e rā hoki. Koe nā te mea matua ki aku kiritaki i enei wānei, me mana, me toka, me whakatau i aua take nei. Ka mutu me titiro tātou ki ngā taua ki whakaraupapa, ngā statements of claim, ngā amended statements of claim. Mo te timatanga o ngā nohonga mo te take o te raupatu, ka mate au ki te hoki ki aku kiritaki, kia kōrero hia taua take rā, hoi anō e tāpai ana i tēnei wā e tautoko ana rātou, me timata tātou i taua take, engari mo ngā rā, me te hātepe, kei mua tonu i a tātou, ko taua take rā, ka mate au ki te hoki atu ki aku kiritaki.
Kia ora, Ms. Thomas. Thank you. In my haste to give sort of an indication of a broad sweep of a timetable based around the research program. I had omitted, of course, to address the logic which you've raised, which is the possible need for amended statements of claim and following the confirmation of the boundaries and those other steps that we're discussing today. So just on the issue of pleadings and amended pleadings, this is not a matter we have discussed as a panel in any detail at this point. So just if I could give this indication, perhaps for Council, we'd be assisted by submissions, and they can be reasonably brief, in the next week or thereabouts, as to how much support there is for a further pleadings phase, and if so, in what level of detail. The issue from my perspective, I'm just speaking from my perspective at this point, is that there's a balance to be struck between the degree of assistance those pleadings provide for the inquiry set against the extra mahi they impose. My own preference is not to impose too onerous a pleading requirement, because I'm sceptical of the ultimate utility of those tools for definition of issues of the kind in a historical inquiry or a district inquiry. So while we're happy to consider a timetable and proposals for further pleadings, my preliminary view would be that those pleadings be refined, but not necessarily in the way or mimicking civil litigation type pleadings, and that the balance we seek is clarity. But anyway, sorry, Ms. Thomas, that's partly in response, but also as an indication to other council. Thank you. Anything arising?
Ai, tēnā koe se, Sir, hei whakamohio no i a koutou ko te take I kōrero pērā au. Mena ka whakawhānui ake tātou I te rohe o tēnei pakirehua e tika ana me whai wāhi ngā kreme katoa ki te tuku I ngā tauāki whakaraupapa, whakahautanga. Mena e tai ana, engari e tautoko ana I tā kōrero e te tiati me whakawhai tipea. Tērā mahi ki ngā kaikreme katoa aua waru tekau mā whetū taku mōhio e noho ana I tēnei wānei te rohe.
All right. Kia ora. Thank you. Ms. Panoho?
Yes, tēnā koe, sir. In terms of the overall timetable, we're not really in a position to comment on any specifics at this stage, but I did want to just indicate for the tribunal that one of the difficulties for our claimants in particular, Ngāi Tamahaua Hapu, is the commitment that they have over the remainder of this year in terms of participation in the High Court proceedings, which has been set down for an 8-week hearing in the Marine and Coastal Area Act proceedings. There's also the proposal to have the Bay of Plenty Waitangi Tribunal Marine and Coastal Area Stage 2 hearings in November. So they're severely limited in terms of the resources and their ability to be able to engage with the research materials and that are produced, even though very grateful for the swift turnaround in terms of the tribunal being able to produce those reports. On the issue of statements of claim, our clients' claims were filed back in 2008, so they're while I note Your Honour's comments about not imposing too much of an onerous task on the claimants, there will need to be a level of updating of those statements of claim, and in particular with reference to the research that does come out. I'm just signalling that this next half of the year is going to be extremely tough for them to be able to meaningfully engage with that research material in order to update their claims. They are supportive of a prioritised raupatu hearing stage if that is to occur, but I wonder whether or not there needs to be a level of coordination amongst Claimant Council and potentially the Crown to see if we can work on a timetable proposal to be put forward if that would be of assistance to the tribunal.
Thank you, Ms. Panoho. That is a good idea, and one which we'll raise at the conclusion of today's conference. Thank you. Mr. Lau?
Thank you, Your Honour. I don't have any submissions to make in relation to the timetable. I do have one thing I wanted to raise was in relation to if we do extend the boundary for Te Pānākai, which would include the Waipawa Forest, there's a possibility of CFRT funding for that. So just wanted to make that, bring that to your attention.
Thank you. When do you think the picture would be clear on that possibility?
So whether the tribunal confirms that they'll be inquiring into their claims.
All right.
Outside the inquiry.
All right, thank you. Ms. Sykes?
So I have several points. I start where Mr. Law left off. Ngāti Ira has a claim before the Crown Forest Rental Trust. We have two eligibility criteria to fulfil there. One is, as has been described by Mr. Law, confirmation that in fact our claims to those areas in Whakapau Pākehī blocks that are within the Mangatu forest lands are actually to be inquired into by this inquiry. And the second is an administrative one, which we can satisfy, which is the need for an independently appointed charitable trust to manage funds if those were received. We have been waiting for the amended statement of claim. The delays with COVID have meant that our application from Crown Forest Rental Trust, which was meant to have been heard, I think in March, was deferred because our claim wasn't registered till this week. Which brings me to my second point. Ka reo I te whakai ngā kōrero a Ms. Thomas. Kei te tino mamai au, nā te mea kei te moho tātou katoa ngā hapu o te pakatoia. Ka rea no I puta ngā kōrero o tana hapu, te hea o rātou nei kreme, te hea o rātou nei rohe rohoi. Ko tō rātou nei tono anahe, e kore e kaupapa kreme hei whakamanahia o rātou nei whakaro. Kei te kōrero Ngāti Ira tēnei whakaro. Kei te huna pēr te krauna, kei tō rātou nei hia, kia whakaoti atu I ngā kreme katoa, I mua I te ata titiro o tēnei kaupapa whakahaere o te rōpu whakamana I te treaty. Koinei te mate o te haerenga o ngā kaupapa negotiations me tēnei kaupapa ināianei. Ka huri atu au ki tērā o ngā reo ke whakamārama mai I tērā o ngā tuāhuatanga. Ms. Thomas' clients haven't actually provided us with a statement of claim. And for Ngāti Rua and Ngāti Ira, there are significant issues, particularly around how people ended up in a reserve that need to be properly investigated. And if we don't have understandings as a prima facie point of those issues, then we wonder how those matters are going to be appropriately responded to by claimants who may have a different nuanced perspective about matters that are being settled in parallel discussions with some hapu that actually support the trust board suit. These issues are fundamental. That's why we want a formal amended statement of claims process. And our difficulty is that we're working off draft documents from tribunal researchers to submit statement of claims. We did this once before in Te Urewera to try and avoid the kinds of delays if we have to wait for final reports. So the reasons why we will be seeking a better statement of claim and pleadings process is we have no confidence that the issues that are being dealt with by this tribunal will be anything more than lip service if the Crown proceeds with its current scheduled timetable for settlement of whakatohea claims. Our claims may be settled before they're actually even researched upon and settled by groups that are present in this inquiry who may actually be delaying matters soon. So we have to raise this with the strongest of concerns. I'm not sure if the panel's aware of it. We've initiated urgency proceedings because this is one of our most significant concerns.
All right, kia ora, Ms. Sykes. I was aware that urgencies, several have been filed and that they are currently under consideration. Can I just clarify, please? You said that the claim Ms. Thomas represents or was speaking to doesn't have a statement of claim?
It has a statement of claim, so it's not particularised. We're also very aware that her hapu is the only hapu within the Whakatohea Māori Trust Board that supports the Whakatohea Pre-Settlement Trust. We would actually like that particular claim better particularised, particularly the boundary areas and the areas of interest where they are claiming for my Ngāti Rua and Ngāti Ira hapu interests.
All right, just clarify with Ms. Thomas. Just if you bear with me one moment. Ms. Thomas, is it just Y1884 that you were speaking to?
Ai, tēnā koe sir, hei tuku pēr i tētahi whakamarama, ai I tukua e aku kiritaki I tā rātou taua ki whakaraupapa I te 19th of August 2008. Koe nā te take, e tā pai anau I tēnei wā me whakatau tātou I tētahi rā, kia whakahau anō e rā taua ki whakaraupapa. Nō reira e tautoko ana, a hau e tautoko ana aku kiritaki I te rā hātepe kia whai wāhi ngā kaikreme katoa ki te whakahau anō I a rātou taua ki whakaraupapa. Nā, ko aku kiritaki anō hoki te rā e heahi ana ki te whakawhānui, ki te whakawhai tipa I a rātou taua ki whakaraupapa. So kāre au te tino kite I te raru, I te rā, I te mea e tautoko ana aku kiritaki I te rā hātepetanga.
Thank you.
That leads me to my last point, sir. I do see value in pleadings. I heard yourself comment that you didn't see how amended statement of claims can facilitate a statement of issues. I've been in this forum for a long time. I've in this kaupapa environment, I can see why there may not be the pleadings that are required, but I believe in the historical inquiries, statement of claims are absolutely vital. They're an educative tool as much as anything for the claimants to understand how they became to be dispossessed. And can I say there is qualitative research that you can use. Mr. Millard QC helped us with the Ngāti Ira one, particularly going through with a fine-tooth comb over some of the other evidence in other inquiry districts. But it took time, sir, and funding is a big problem because at the moment legal aid is still a difficulty for some of our claimants, but our people are absolutely committed to getting their history uncovered, and they find the factual understandings from a statement of claim very helpful to at least see clarity of their proposition. It may not be a proposition shared by others overlapping claimants or even the Crown, but it's their propositions that they would like available to be considered as part of the totality of matters before we narrow issues. And that is where I think we have the tension of a parallel negotiation process that is set by a timetable to finish things as soon as possible. I understand in public statements that we have a commitment from the present Minister to do something by October of this year. Well, on your indication, that would mean a settlement's being driven and our claims may be settled before we even start.
All right.
And that's our concern.
Can I just clarify, Ms. Sykes, in terms of the comments I made about the statements of claim, I wasn't suggesting no further pleadings as such. I was indicating that a balance would need to be struck between a highly detailed pleadings, which may be onerous, versus pleadings of a more general character. And the reason I was raising that is partly aware that from the commencement of this district inquiry, the issue of the parallel negotiations and the need for this tribunal to do what it can to respond in a timely way is a factor we are aware of and will try to respond to as best we can. So that's the context for the observations about how far we go with the pleadings process and what kind of time we build in for that.
So we would like it front-end. We anticipate our pleadings being done before Christmas. We think it's vital for researchers that are working, that they understand what's being claimed, and so that they can actually focus in their reports to those issues. We have been quite critical of the draft we've seen. I don't want to do that on this call. There are comments that we've made to the Research Coordinating Committee. It's not of the quality that we've seen in other Raupatu areas, I would just say that. And that's been a criticism by my claimants for some time, both with the Crown material that was used for direct negotiation, but even this report we say, for instance, it doesn't actually quantify the actual amount of Raupatu land that was confiscated. It's an obvious fact that should be right up front, and it's still unclear. So, you know, I just raised that, sir. We understand the constraints. We're trying to do this in a way because we are aware of this parallel negotiation process, but we have an obligation to our claimants to uncover the history as accurately as we can as a first point.
All right. Can I then suggest that the implications for timetabling proposals arising from this discussion form part of a follow-up written submission, and then we'll take your submissions into account along with other council in looking at a realistic timetable going forward. Thank you.
And can I say, I'd love Ms. Lindsted Panoho to be our coordinating council if she's offering, because I agree, sir, that role that's being instituted everywhere, if we have a good coordinating council, they slap people like me around and we get things done, sir. So I'm very happy for her to volunteer for that role, if that's what she said. But that's certainly a role that I would support, sir.
Okay, as would we. So perhaps if I just check with Ms. Lindsted Panoho right now.
Not to be put on the spot or anything, but I'm happy to, sir, but maybe have further discussions with council.
That's probably prudent. All right. Can I just, thank you for your on-the-spot indication, and perhaps if those discussions could take place in the next short period, and then council could let the tribunal know if you've reached the happy place of unanimity, that would be great. Thank you. Mrs. Cheney, sorry.
Tēnā koe, sir. No submissions to make on the timetabling, other than supporting the nomination of Ms. Lindsted Panoho as coordinating council.
You look very relieved.
Just two quick matters, sir. On our claimant supported the application by Ngāti Ira to CFRT, and I imagine an updating memo will be filed by Y864 and Y558 as matters progress. In terms of filing an amended pleading, our clients are certainly supportive of filing. Mr. Hollis filed an amended statement of claim in 2013. So we would welcome the opportunity to refine that statement of claim. And it's critical for this claim, and with the passing of Mr. Hollis as the principal knowledge keeper for this claim. So once research becomes available, particularly around the public works takings and the Mau Tohora quarry, our clients would certainly welcome the opportunity to file amended pleadings.
Thank you. Ms. Doherty Ware.
Kia ora, sir. I don't have any specifics in terms of timetabling at this stage, but I just wanted to add that for the Y2510 claim, Raupatu is a priority issue, and it is my understanding that some research is being undertaken at this stage, as there's very limited research being undertaken in terms of the descendant relevant to this claim, which is Te O Te Kahika. So I anticipate there may be some need to update this claim once that research has been completed. But if I may seek further clarification from the claimants as to the progress and the detail of this research, and provide written submissions in due course.
Thank you. Mr. Silveira.
Tēnā koe te kai whakawā. E pērā tonu ana te kōrero e tautapu ana i a ene. Koe rā noi ho. Kia ora.
Kia ora. Thank you. Mr. Tupara.
Kia ora, sir. Ka tautoko ngā kōrero I kōrero tia e taku hoa Annette Sykes. Ki te whakaroaroa ngā kirime ki te Traipūnara, I would definitely support the opportunity to file amended statements of claim, particularly in regards to, as not too dissimilar to many other claims that were due to the time limitation that was imposed on claimants to file in 2008. The Y2006 claim, which we represent, sir, is presently still a one-pager, and we would seek to elaborate on that subject to the timetabling that you introduced, sir. Kia ora.
All right, thank you, Mr. Tupara. Mr. Lyle.
Kia ora, sir. On timetabling, I support the comments earlier that as long as current commitments are taken into account, I'm sure that a workable time table into the future can be negotiated between Council and presented to the Tribunal for approval, led by Mr. Linstead Panaho, who I have absolute faith in. I would say also that I think there's force in your view that perhaps pleading of that fine-grained particularity as seen in some previous inquiries might not be of as much assistance as it was there. So I'd support a slightly more generalised pleading, so long as the evidence does contain that granular level.
Right. Thank you, Mr. Lyle. Mr. Beaumont.
Kia ora, Sue. We support what's been said about timetabling, and our claimants would certainly welcome the opportunity to further amend their pleadings. No further submissions on that, sir.
Thank you. Mr. Benyon.
Kia ora. Yes, we support submissions of Ms. Sykes on these issues.
Thank you. Mr. Ketu.
Thank you, Sue. Yes, just to echo support for other submissions made by Council, and just to reiterate, my claimants, that's Y203, are involved in a number of the proceedings as previously mentioned, and as long as that's taken into account in terms of timetabling any amended statements of claim, that would be much appreciated, sir.
Thank you. Ms. Alexander.
Thank you, sir. I don't have anything specific to add, but I understand that our claimants would like the opportunity to file amended statements.
All right, thank you. Mr. Sinclair.
Thank you, sir. In regard to timetabling, I support the comments made by Ms. Panaho, sir. in regard to the workload and the matters facing the Whakatōhea-wide inquiry, sir. In regard to amended statements of claim, sir, our claimants would like the opportunity to be file and be a lot more specific on particular matters within Whakatōhea, sir, over and above the raupatu. And in regard to CFRT support, sir, the claimants have done as much as they can at this stage, sir. So we'll certainly report on any further developments, sir.
All right. Thank you, Mr. Sinclair. Mr. Lincoln.
Kia ora, support the idea that your timetabling directions to come would just provide some space for council to get together and talk about these things among themselves and come up with the more granular version of it, as it were, so that council can work through, for instance, all of the competing matters they're involved in, how to strike a balance between those people who would prefer to proceed as is and those people who would prefer to provide more detail. On that point about specificity, the key issue for the Crown is that there is knowledge upfront as to what's material to the claim, both in terms of founding it jurisdictionally against, treaty breach causing prejudice, but also just simply so that we know what it is we have to respond to and come to the tribunal prepared to talk to. I think there's a consensus for an exchange and some time to be provided for these timetabling issues to play out, but an early indication from the tribunal as to when it expects it to all have wrapped up by would be very useful, so that in the discussions between council we can keep an eye on that clock ticking away there. Kia ora.
Kia ora, Mr. Lincoln. So by wrapped up, do you mean commencement of hearings as the wrap-up date, or finishing the inquiry proper? No, I'm meaning knowing what our timetabling proposition is through to the end of getting the statements of claim all up to date, any Crown response, and the statement of issues. In other words, wrapping up everything that has to be done before we can start hearings. All right, thank you. Can I just check if the panel got any questions at this point? Do you have any questions? It seems, just if I could just raise this before we come on to the last matter on the agenda, I had indicated that we would allow another week for supplementary submissions from today's conference. Perhaps rather than requiring a two-step process, it might be better if we allow a little more time for the range of matters to be addressed in submissions following today's conference, and also to allow discussion over agreement on a coordinating council role, and possibly some preliminary discussions amongst the parties, including the Crown, around what a realistic timetable to the completion of pleadings, and possibly the consideration of a statement of issues, what that timetable might look like, having regard to the heavy commitments of a fair number of counsel in this inquiry. So if on that basis we allow, say, 1 month from today for the filing of submissions on any and all matters arising out of today's teleconference, that might be more realistic to enable some of those discussions to take place. So I'll just seek your responses to that proposal when we come to seek responses on the final agenda item. So if council could just keep that in mind, and if we just come to that final matter, which is an update from the Crown on the settlement negotiations. So Mr. Lincoln, could you speak to that, please, and then I'll come to Claimant Council. Can you hear me, Mr. Lincoln?
Yeah, we do. I can't hear, sorry. Has he asked something of us?
Mr. Lincoln, can you hear me all right?
Got you now, sir.
All right. And Mr. Hunt, I can see you there as well. So just seeking a update from the Crown on the settlement negotiations, which is the last matter on our agenda, and any further updates you can provide us around the timing implications of that and the nature of the modifications to our jurisdiction that are likely to flow.
There's nothing definite to say, sir. The point we've reached in the electoral cycle means that a number of things are going to come to a pause point in the next couple of weeks. The current government's work plan does have work with the pre-settlement trust to see if can't get to the point of initialing a deed, I understand, by the end of the year, but any decisions on that have yet to be taken and would logically be taken later on, I'm assuming after the election. The ratification process thereafter would be in the early part of next year, if that timing all holds. And it would be at that point that the community who's asked to consider the proposed settlement would be forming a view on what the impact of that would be on this inquiry. If that all sounds very contingent, it's because it is somewhat. But as I presently understand things, it wouldn't be until February earliest that there would be a ratification process, and the outcome of that process in consideration of it, if it led to deed of settlement being finalised, would at some point thereafter lead to settlement legislation being introduced. As the tribunal is aware, the introduction of legislation has the effect of suspending the tribunal's jurisdiction, and so these are all matters to work through very carefully and on notice to everyone as things become more concrete. But right now they're simply not. The ratification materials to be developed, I understand, would be the process by which the community would consider whether, if they wish to go down the settlement track, they therefore also wish to have a form of inquiry that is able to make findings and not recommendations.
Right.
So yeah, that's the situation as I understand it, sir.
Thank you. Can I just seek some clarification on that last point? Is it your understanding that as part of the ratification process, Whakatohia will be asked not only to indicate support or otherwise for the settlement itself, but they'll also be asked for a view on how this inquiry ought to proceed and to what extent? Will that also form part of ratification?
So I just don't know at this point whether it's proposed to have multiple questions. As as you'll be aware, Your Honour, multiple questions can pose challenges as to whether you get conflicting answers. I think it's fair to say that regardless of whether we end up with one question or more than one question, the important point is that the material accompanying the ratification proposal, whatever that should be, but that the material accompanying it explains very clearly what the intended effect would be of approving the settlement on the tribunal inquiry.
All right, I follow. Thank you. And presumably, if one of the outcomes of the ratification process was that support for the settlement was low or quite compromised by division, that would be a further factor that the Crown would have to consider at that point in terms of how to proceed.
No, I'm sure that's correct, sir.
All right. And just finally, in terms of the indication just previously about a month to make submissions and to allow some discussion amongst the parties about an indicative timetable towards the end of pleadings and statement of issues, is that period of a month seem sensible to you?
Oh, yes. Yes, yes, sir. And I don't have the competing commitments that some of the other people do, and so if I need to come to the foyer of the High Court at Rotorua to have these discussions in the lunchtime, so be it. It's really a matter more pressing to the other council, I think.
All right. Thank you. Thank you, Mr. Lincoln. So if I could just come to Claimant Council on that point, and if there are any submissions that Council wish to make on this last agenda item. Ms. Rongo?
No submissions, sir.
Thank you. Ms. Thomas?
Ka whai noa i au tohu e te tiati ai, ka mātua i tēnā.
Okay, kia ora. Ms. Panoho?
No submissions on the timetable, sir, but just to reiterate our client's position, positions, all three of them are opposed to the settlement and are in favour of a comprehensive tribunal inquiry. So that's just to record again their position for you, sir.
Thank you. Mr. Lau?
No submissions, Your Honour. Just to point out that no submission, sorry, Your Honour.
Thank you. Ms. Sykes?
I don't want to relitigate a matter that's in another jurisdiction of this jurisdiction, so the urgency, I think, will proceed. I don't think that's been factored into. That's my assessment of the fact that there's now something like 24 of 31 claimants that have either applied or are interested party applicants to the urgency. So I think there are difficulties for the Crown to proceed. Our biggest concern, sir, is the withdrawal mechanism. Ngāti Ira, in your vote, voted no. They want to get out. It's and it's a significant position for them. It wasn't a marginal vote, and they still have not been able to extricate themselves from a process that is taking away their rights to seek a comprehensive hearing of their issues. I think that's a similar position for my friend, Ms. Linstead Panoho. Her group, Ngāti Tai Tamahoa, they also voted no. So I think in our view, if we were able to withdraw and there was a proper withdrawal mechanism, that would actually be the best way to ensure certainty for this forum. I'm very clear that we would meet any threshold that's now proposed in the withdrawal mechanism that we've seen. It's the problem is that there's been no effort to give practical effect to it. No, I think you have to look at that as well at the same time as we're looking as an update on negotiations. If, for instance, we had to get 350 people tomorrow to withdraw, we would have 350 people to withdraw. We would have funding to set up our own hui, and I think we would have an overwhelming majority of those claimants that we represent seeking to have their claims withdrawn from any settlement processing. And that would then avoid an enormous amount of stress for them, because they're so engaged not only in litigation, but in so many hui. They're actually worn out by this process. And that's just to protect their positions.
All right, thank you, Ms. Sykes. I think if urgency is granted to all or some of the current applications, I think we as a panel will seek submissions from the parties as to how we should, what would be required of this panel while those urgencies are addressed. So we'll keep an eye on that and likely seek submissions if and when urgency is granted as to what implications that has for our timetable.
Thank you. I missed Zelvira may add, but we now act for Ngāti Rua. You might remember when we did the first urgency claim, they were part of the Trust Board support team, cheerleaders for the Whakatohea Pre-Settlement Trust. They are very clear as a iwi hapu. They no longer wish to go down a negotiation path. They're completely committed to a Waitangi tribunal process. I think we can say that there are now 5 of the 6 hapu on the Whakatohea Māori Trust Board who are certainly, I think, against negotiations proceeding until this process is completed. And that's really where I think the urgency will focus its debate. You know, the fact is that the community opinion has changed in the time that has elapsed since the vote.
All right, we'll await developments on those and seek submissions once we know what's going to happen with those applications. Mrs. Cheney?
So just reiterating my client's position opposing the current settlement negotiations, our clients also filed an application for urgency, and yes, we'll await the outcome of those applications, sir.
All right, and the 1 month that I'd proposed for submissions from today, from this conference?
Yes, sir, and I just raised our internal difficulties around meeting that deadline. If an extension is required, a memorandum seeking Your Honour's leave will be filed ahead of that 1 month deadline, sir.
All right. That's an ominous sign. Ms. Doherty Weir?
Kia ora, sir. No further submissions, but wish to also point out that my claimants have filed for applied for urgency and interested party status, and so continue to oppose the Whakatohea mandate at this time.
All right, thank you. Mr. Silveira?
Tēnā koe te kai whakawā, e pērā tonu ngā whakaaro, e hihi ana Ngāti Rua ki te wānanga tai ki te tribunara, moenei ahuatanga o tira kāre rātou I whakai ki ngā pre-settlement claims. E pērā tonu ana ngā whakaaroa ene, nā rea tēnei au e taunaki nei ana kōrero, e mihi ana.
Kia ora. Mr. Tupara?
So kāre he kōrero, no submissions. Sir, with your leave, I have to attend another Zoom hui, if I can be excused, sir.
Yes, thank you, Mr. Tupara. Mr. Lyle?
Sir, I've found the top of a hill, so you might be able to see me now.
Yes,
but all that to say that I have no submissions concerning the settlement.
We appreciate your effort. Thank you. Mr. Beaumont?
Kia ora, sir. Just to say that our clients for Whakatohea will be filing in support of the urgency, either as interested parties or making a full application in support. Apart from that, no further submissions, sir.
Thank you. Mr. Benyon?
Thank you, sir. We're also supporting the urgency, and just to note that if the urgency were to proceed, I don't think, in a preliminary way, we can see at the moment that there's nothing that suggests that we would slow down the hearing here, because the Crown thinks it wants to go to a settlement and is happy with the timetable that gets the historic claims heard, and we all want the historic claims heard in a reasonable, timely fashion. But we'll come to that bridge if we come to it.
All right, thank you. Mr. Ketu?
Thank you, sir. I thought I would just raise that the High Court proceedings that are being referred to commence on the 17th of August, sir. They're scheduled for 8 weeks, so that would have them ending on the 9th of October, just so that the tribunal is aware. And so I just wanted to support Mrs. Cheney's submissions around meeting the deadline for submissions. We will file a memorandum seeking an extension if needed, so just to take into account those proceedings.
All right, thank you.
Thank you, sir.
Ms. Alexander?
Thank you. No further submissions, sir, but I note that our Te Upukurehe claimants are supporting the urgency application.
Right, kia ora. Mr. Sinclair?
Tēnā koe, sir. The only submissions I've got to make, sir, regarding the 3 applications I'm representing here today, is that further ongoing discussions happening regarding the urgency, sir, but instructions and a definite positive for or against should be received, and I'm picking within the next 3 to 4 days, sir.
All right, thank you. Panel, have anything at this point? Research concerns? Should we ask if it's formally, Tom? You mean asking for submissions on their concerns about this? Yeah, well, they had some, but we don't know what they are. Yeah. Would it be something I should ask them to? Okay. Any questions? Kia ora. Mr. Lincoln, is there anything arising that you wish to address?
No, thank you, sir.
All right. Thank you, everybody. There's just one matter that Dr. Phillipson has drawn to my attention. So, as I indicated, we will allow a month from today for submissions on matters arising out of today's teleconference. Dr. Phillipson noted the points raised by Ms. Sykes about a number of concerns her clients have with the research or the adequacy of the research currently available. Can we also ask, please, for any party that has concerns or proposals, further proposals to make in relation to research or perceived gaps in the research, particularly with regard to the Raupatu issues which we are endeavouring to prioritise, could they be signalled, please, in the forthcoming memoranda? It would also be helpful if Council could discuss and agree on the appointment of Coordinating Council, and we look forward to confirmation of Ms. Panoho Lindstead's possible new role. We'll reserve leave to parties to apply for further directions if the need arises. But otherwise, I just wish to thank on behalf of the Tribunal everybody for their attendance and for the helpful submissions made today. And I'll just now hand over to Te Matua Tom to close. Thank you.
Respectfully, Judge, I wonder if we might turn to Mr. Rakuraku, who didn't have an opportunity to respond to the mihi, and perhaps e koro kei a koe pia te kupu whakamuitunga hei whakakapi tā tātou hui.
Kei te kai whakawa, tēnā koe. I tō te epu ino, ia koutou no mai I tō taha, wene rea ta mihi ana tira kia koutou, pai te rongo ki nā kōreo, e tame tēnā koe. A hoi whakatau I a mātau, anei rā te rua e tau toko ia o momi o kōreo katoa, a te simatanga taino ki te mutuka. Kei nā roia, tēnā koutou, tēnā koutou katoa. Tēnā koutou, tiro pai te tūtaki a koutou, me te rongo ia ki o koutou kōrero e ara mai, ai tēnā kreme, kai kreme, tēnā kai kreme. Nori e koe nei, a te rua e mihi ati kia koutou, tēnā koutou. Kei te korauna tēnā koutou, pai te rongo kia koutou e kōrero hia, wa koutou hia e pāne ki te kaupapa nei. Nori e kāre toro nā mihi, aloha te kāre e taku koraua teriaki I konei, te tikanga, kai a ia te mihi, kai a ia te karakia, tēnei wāko, mai tēnei wahanga kia hau, e tame kia aukati te tātou hui. E honore Gloria Maungaro ki te whenua pakaro pai ki nā tāngata katoa. E hua te mātua tamata wairua tapu nei rā mātou o poranga e tuku whakamoi me te kia koe. A hui chaki ai manaki I a mātou mai te tīmatanga o tēnei hui ngā taino ki tono mutuka I tō mātou kaipura. Kaino te a koe tō mātou kaipura ki taipai mātou, tō mātou tari, tō mātou pānua kaipia rā mātou e nohana e tō mātou kaipura. Ko koe haimuri ki unkau. Ki raro ki nā tāhi a mātou, a tēnei mātou ka ena te a koe tō mātou kaipura. I te tīmatanga te kupu ko te atua, te kupu ko te atua tau kupu o te tīmatanga, nā mea katoe hangkari ma kore te hanga ia. Ia te ora ko te ora te māramatanga mo nā tāngata katoa, I roto te paori te māramatanga piti ana, I o ki ai mai te paori krori ki tō ingoa tapu. Parei nā pete e te atunga tapu e nōna I te rangi ki atata mai taoringa matau ki te pakori a mātau. E ua te pai o nā tāngata katoa I nā tuaroha, a wikana ki te riri tāu mahi tau, mai ana koe I hua ki nā mea katoa, e rungi a mātou tāu manakitanga krori ki tō ingoa tapu, e tai wai o tino I a te kraisi, e tō mātou matu e te rangi ki a tapu tō ingoa, kia tāu mai tāu rangatiratanga, kia metia tāu e pai ai ki runga e te penua ki ari te anō ki tō te rangi kua ka moemesi. Kua ka moemesi nei o ki mātou kia koe paka krori ki tō ingoa tapu. E te atua tahuri mai o tangi kia mātou ino I kaipakana rasu e tangi atu nei. A ngā mai te tiro mai kia mātou e pōkai kātangi nei hoki rōri ki tō ingoa tapu. E te atua pakatūparatia mai nā kua te tika te māramatanga kaha te pono te ora kia mātou katoa I tēnei rā a mātou koe puka moemisi paka rōri ki tō ingoa tapu. Āmene.
Āmene. Taure e koro. Tēnā koe te rua.
Kim, could you keep us as a sort of a subgroup? As a